A very interesting innovation had come up on Shark Tank 3, and there was some to and fro between the founders and the sharks regarding this innovation, which is what I want to discuss. But before that, watch this clip first.
प्रोसेस को जो बनाया जैसे 100 डिग्री स्टीम, क्योंकि इसमें 40 तरह के फ्लू होते हैं। अगर हमें इस कचरे को छूना या रैक पिकस इस कचरे को छुएगा तो वो कैसे छुएगा? तो उसके लिए हमने कि उसको 100 डिग्री स्टीम में प्रोसेस करना है, फिर इसको हमें सोप नट से वॉश करना है, फिर हमें इसे एलम से प्रोसेस करना है, फिर मुझे आइस में प्रिजर्व करना है, और ये मुझे सिर्फ 24 घंटे के अंतर में करना है, क्योंकि फिर से हमारे यूनिट में वो कचरा रिपीट में आ रहा है। पानी के साथ यूज करना।
मशीन इन्वेंट करी है, स्पेशल मशीनरी में समझ नहीं पा रहा अभी तो आपको पेटेंट किस चीज का मिला है?
सर पेटेंट प्रोसेस पेटेंट मिला है।
और उसमें क्या मिला आपको एग्जैक्टली कि आपके अलावा दुनिया में कोई ये वेस्ट यूज करके
तरीके से ये नहीं बना पाएगा।
Now, in this clip that you just watched, Amit Jain talked about a process patent, which is one of the types of the patent, and he also alluded somehow that if somebody happens to acquire a process patent, then nobody in the world can follow that process and create a product. But this point which Amit Jain raised needs slightly legal tweaking, and that is what I'm going to tell you. Okay, so first of all, what you need to understand here is that in case of intellectual property, including patents, the rights that you get are very much limited to that jurisdiction in which you get those rights, and they're not applicable to all across the world. Which simply means that, for example, if I get a patent granted here in India, I can only enforce that patent here in India. But let's say somebody else is using the same process in UK, then I cannot get it enforced in UK unless I have a patent granted there in UK as well. And what this means legally is that intellectual property rights are not global in nature, rather they are territorial in nature. And this phenomena is not limited only to patents but also to trademarks as well. And one common example in order to understand this is the example of Burger King's expansion to Australia in 1970s. And it was in 1970s, Burger King had already been operating in various jurisdictions, had trademark registrations in those jurisdictions. But when it decided to expand into Australia, it realized that somebody in Australia had already trademarked the word Burger King, and that is why they could not use this mark in Australia despite having trademark registrations in other jurisdictions.